Okay, I think we're about live here. I'm going to go ahead and start getting into this as I promised earlier. And I was going to wait for some people to show up, but I'm recording this for YouTube viewers, so I will at the end stop the recording and go in and listen, do the watch the Facebook comments and get to those as soon as I'm done here. So reason for this video is to cover this right here. This is the segment that I've talked about several times from the Black's Law Dictionary, 10th edition, page 638. Okay, now, if we look at the basics of the word emolument, it dates back to the 15th century. Okay, it was not until 1991 when the authors or whoever decided to make this suggestion to input this into the dictionary about our constitutional law. Now, if you look at the definition of Emoluments Clause, they've defined number one, but they have not yet to define number two, Foreign Emoluments Clause. Okay, we've discussed this on the show more than a few times as to how you take for example, the word domestic, and they've used it to trespass into your home. They took the word tranquility off and put the word violence into it. Now, because the word domestic appears and there's violence associated with it, these quote-unquote bar actors have sold to Congress, hey, we should be able to trespass into a home for a domestic violence situation. That's how that evolved. So this is nothing more than another repeat of that same perversion of language, okay? So what comes up, now of course, let me backtrack a little bit here. When I first started this, back in, I would say, early 2017, the Ohio when I first started to include Ohio in the correspondence in this, it didn't take long for the Ohio Democrats to come up with their version of a prosecution against President Trump, which the federal court pretty much laughed them out of court over, right? Because here's why. They hadn't proven any foreign collusion. So when we talk about why do they need this Russia probe? Why are they all over this? And the answer is page 638 of the Black's Law Dictionary, Emoluments Clause, definition 2. They're literally trying to write this into existence to change the meaning of the word, the base word emolument, to be into a weapon, something they can use against political enemies, right? So again, just because of how I've always done business and I see things that other people don't, point is I spotted this, okay? And let's go, and then that said, now let's dive into the basics, right? As far as loss prevention is concerned, along with everything else, there's an ideology. And the ideology is basically comes from this legal maxim. Everyone is the manager and disposer of his own matters. Okay? That's basically what it is. And in the private sector, this is the management tool, right? The disposer of those malicious designs that I talk about, right? So this was part of my job, back in the day when before I had dealt with any of this crap. And so kind of give you guys the idea of how I was able to apply, okay, the ideology behind loss prevention, which is the malicious designs of men must be thwarted, based on everyone is the manager and disposer of his own matters, right? So, I mean, it seemed pretty simple. Here's where it started to get really ugly for a lot of bad actors in my case. What they didn't like is they didn't like that I had this tool in my toolbox, right? Called this fiduciary license, which I had in escrow at the time. And I said, you know what? Because I know the difference between theory and practice, I'm going to pull out this tool out of my toolbox. We'll just call it a screwdriver, for lack of a better expression. And I'm going to use this to apply to and demonstrate as to why the fiduciary duty is the strictest duty of care recognized by the legal system, which of course goes to my notice of appearance in, I think it was this document. Yeah, right here. This is actually from the actual legal definition. This didn't come from the Black's Law Dictionary. This actually came from a court. And I think it was Supreme Court, but I'm not exactly 100% sure. I'd have to go back through my notes and find out. But the point was I wanted to introduce myself, my corporate charter, right, my corporate mission statement, as the preamble to the Constitution, along with this line from the Declaration of Independence. To prove this, let these facts be submitted to a candid world. And the whole thing, the whole premise behind it is under the fiduciary duty or agency practice recognized by Congress, the one they wrote, okay? Full disclosure and truth in the record. I mean, all of these things are a requirement, okay, to ensure that a contract is, number one, lawfully created, number two, lawfully executed, okay? So along the way, during all of this, I said, because the word emoluments is so broad in its definition, okay, and its definition is any advantage, profit, or gain received as a result of one's employment or holding of office, which goes back to the actual definition, right? I just showed you. That's where this came from. I had to figure out a way to try to expound on that or clarify that further without going into their, playing into their hand, which was their quote-unquote Emoluments Clause. So I said, okay, you bar members are going to play this your way. I'm going to play this my way, and I'm going to go based off of my ideology, which of course comes from Latin, the language of the court, blah, 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 my history, my experience. And I found this legal maxim. In order to rightly comprehend a thing, it is necessary first to inquire into the names, for right knowledge of things depends on their names. Okay? So, because that's a maxim of law, basically a maxim of practice of lawfully recognized process or procedure, okay? And we get into the, and we've done this through the Mason's Manual more than once, which I'll recap when the time comes, okay? Now remember, this comes from my notice of appearance when I walked into the state level appellate court. So when I announced who I was in my person, I did so under the preface, okay, here, right? Everyone is the manager and disposer of his own matters, right? Again, another maxim of law. And that was the preface of how I wanted to introduce loss prevention to the Florida state legal system. Having to advise them that, look, this brief is a supplement. In other words, you guys unfortunately kind of got sucked into this thing during the middle of it. So I had to figure out a way to inform the court, inform the judge properly and right up front that, yeah, dude, I know you kind of got sucked into this thing in the middle, man, and I'm really sorry to have to drag you into this. I didn't do this, right? but this is kind of, this is where we're at. So that said, let's just bite the bullet and I'll explain as I go. And of course, because of the way, I'm not just the way I write, but the fact that it's obvious that I take a lot of time and I put a lot of care and a lot of effort into my document. And it was to let him know that this document is prepared in addition to previous reporting to address the continuing emoluments violations, excuse me, as related to agency practices, guidance documents, those policies that we talk about, court rules, and integrity issues of this matter consisting of 11,212 words and 51 pages, not counting appendix. Okay? And the reason that this was important to announce this up front, remember, full disclosure. Part of the rules is, or one in the requirement, which is a certificate of compliance, how many words on how many pages. Okay? So I'm telling them up front, it's full disclosure. Right? They can't fault you for full disclosure. So, and again, under that initial preface, these matters do negatively affect public trust in this governing body's ability to perform its tasks. Okay. There's some key words in this statement because I've clearly stated because the circumstances, and they already knew about Article 1, Section 11 of the state's Constitution. We'd already covered that. What I was trying to clarify, and of course he got it, which led to them, him issuing me this mandate, right? Which I'll cover in a minute. And part of his job as the judge is to look for this negativity. Anything negative has to be dealt with by the court, okay? And the only way the court can take an action is if it is before the court. Okay, so I'm informing them that there's a lot of negativity here and it's affecting or negatively affecting public trust. Okay, again, the judge's primary function is to maintain public trust in the court. So, which of course he figured out when he, into this next line, when in consideration of agency practices. Well, when you're talking about agency practices, and in this case, it was the Department of Revenue. Oh, that's a state agency. That's an agency practice. Got it. Okay. So that means now we're talking about policy, talking about guidance, right? We're not even getting into the law yet. Let's just start with the policy of it. Okay. And how those practices violate the cited language, the language cited in the Declaration of Independence is the difference between an unlawful versus an illegal action. Okay? This is me informing him, look, we already know that these things are, that these agencies as they're constructed are unlawful. If they were not unlawful, I wouldn't be standing here, right? That's pretty much a given. The best example of such an unlawful emolument in context is best observed by the administrative order which grants the state agency an advantage, but clearly reduces counsel by excluding government agencies. Now, one of the requirements of agency is equity, quality. You have to be able to, if you're going to provide a service, there has to be a mutual benefit to both sides, okay? So when you tip the scale by providing an advantage to one that you don't provide to the other, okay, that negatively affects the integrity of the process, right? And again, having announced myself on the cover page as a licensed professional, okay, this is me informing him that, this is how this is going to work. So that is what I mean when I say a special emolument or / privilege, okay? So if there's going to be an emolument or a privilege, two things are required. Number one, Congress is the only one that can assign privileges of any kind or immunities. Why? Because the Constitution says so. So technically speaking, this administrative order of 2018, which is attached in the document later on, would fail upon a challenge. And of course, I think the reason that they actually constructed this was because I think it was his way of throwing me a bone to see how I would handle this. And because I handled it properly, I didn't come out and say, you're a piece of crap, you did this unlawfully, blah, blah, blah. I said, the article, the practice is unlawful because of the privilege or advantage is an emolument. It is an example. So when I went into, and according to that maxim of law, right, we have to inquire into the names because our right knowledge of things depends on their names. Right now we're talking about emoluments as a privilege, okay, and or an immunity. Again, that's a usurpation according to constitutional law. That's a constitutional argument, and it must be made in Congress, not in the court, right? So as an individual rule, this may seem ambiguous or insignificant, yet when consideration of the extensive labor this practice has riddled itself with in most of its rules and nearly all of its guidance documents, okay? So what did I just do right there? I walked in and said, look, on one premise, when we walk into this thing called this de facto courtroom that you're claiming is under a certain set of rules, okay, there's a subset of rules that are called guidance documents that you don't even see, right? So now we have another malicious design. This stuff is not only is it not legal, it's not lawful. Why? Because Congress didn't enact it. Congress, they would, of course, the other side will argue, well, Congress enacted the agency, blah, 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 blah. But if there's going to be a trespass or a redress because of a usurpation, excuse me, whatever that is, if it violates the 10 principles under the Mason's Manual of the Process, we have to know what those are, which of course is why I provided them, right? So this redress process becomes weaponized to reduce the people of the state of Florida and placing them as an adversary against the government, okay? That, of course, is a true statement. And everybody, pretty much everybody knows that it's unchallenged. I've been saying it since minute one, okay? The fact that this is a clear act of treason as defined within the Declaration, meaning the Declaration of Independence, leading to mock trials in kangaroo courts, violating the Emoluments Clauses of the several states listed in these authorities. See Article 4, Section 2 of the U.S. Constitution, and this is where this applied. More specifically, in my case, I not so much Section 1, but Section 2, because I was targeting at this particular moment this specific privilege or advantage emolument. Okay, so just kind of clarify that. And doing what I do, I always take and finish up the preface with some language from the Declaration of Independence. In this case, it was talking about the patient suffrage. The patient suffrage in this was an unlawful detainment or false imprisonment, right? I would call that a patient suffrage. So again, and when I went in there under the Reis Excipiendo Fit Actor, right, the defendant by plea or exception becomes plaintiff, that goes to why, in the case style, this judge, as the witness, told the clerk to change this around from the Department of Revenue versus me to me versus the Department of Revenue, right? We have to be very careful and read these things top to bottom, left to right, blah, blah, blah. So knowing full well that I was taking this to Congress, right, to deal with this in the proper forum or quorum, right? That's what it's called. It's called a quorum. I also proved that because the agency is unlawful, that also excludes, by definition, my ex. So I'm able to protect her by definition in that this agency, these actors, are acting unlawfully. They can't do what they're claiming to do, so I'm severing that connection. And by severing that connection, ultimately, in the end, actually defends her, which is almost kind of one of those oxymorons, which is confusing to say the least, especially when you consider all of the crap that we've been through. So anyway, I just wanted to kind of cover some of those basics as we went into this, because when we talk about what the, where does this come from? How did this get started? Well, I mean, I think it's pretty safe to say that if we were to call this treachery, I don't think it would be a hard sell to a jury of my peers that treachery is somewhere in the mix here, right? And the fact that confidence men are in play in the document, throughout the document, and confidence itself, right? Remember, we were talking about public trust in the court, public trust in government. That's confidence. Well, those are confidence men or confidence man by definition. So when we talk about these actors walk into court and lie, here's what this is. This is comes from this legal maxim. And here's the reason they do subordinate perjury, right? Because to lie is to go against the mind. Now, for a man, we just kind of sit here and go, dude, there's no way you're this stupid. Men can shut emotions off. We have that capability. It's an unfortunate side effect or circumstance for women, and for a lot of the moms out there who are watching this. They don't have that capability. It's not a deficiency. It's one of those inherent differences between men and women. Okay? And, one isn't right, one isn't wrong, one isn't any better than the other. There's advantages to not being able to shut that off. In this instance, when you're doing battle like this, when you're dealing with mind games, right, and knowing that this maxim of law is in play when subordinating perjury, this is a direct assault, excuse me, on the female psyche, because women can't shut that off. So they can't defend against it, right? It weakens their position. So now when we go into the actual designs, the models of what our government looks like, right? We're taught in civics that we are a republic, okay? Our republic is comprised of these three equal branches: executive, legislative, and judicial, right? Which, when you read the Constitution, if you have a redress or a grievance, you're to petition those, you're to write your petition to the legislature. Remember, in the republic model, there's no bar. That didn't exist, right? So when we talk about these things on the show, and when Kirk and John went to DC and they saw that petition for divorce in the, hanging right there in the records building, it was oh my Lord, yeah, we're supposed to petition Congress with our grievances. So what came later on during the Restructuring Act, right? They reinserted this bar and reinserted itself, calling itself a representative democracy, okay, in that this is the corporate or de facto government, okay? This is the one that we technically use to do business with, foreign business, right? Whether that's make a deal with, Russia, China, North Korea, whoever, okay? This corporation that we use through the State Department, right? That's why it's the Department of State, okay? The Department of Justice came later. The Department of State was actually the only lawful department in our de jure form of government, okay? So this is what I'm saying. You got to know the difference between the Department of Justice and the Department of State, which is why, like, for example, when you go get a passport, you have to get those through the Department of State. They're managed by the Department of State. So as we devolved and we started to include this thing called excuse me, family law, this bar mechanism has re-wedged itself, okay, this deep state has re-wedged itself back into our style and form of government, henceforth altering the design of our system of justice. Okay. This is why right here, and the Supreme Court knows this, which is why they always say there's no jurisdiction, because in the Republican and the de jure form of government, until there is a legislative scope document issued, okay, because we can't sue criminally. The only way we can sue criminally is if we get that scope and authority from Congress, that special emolument privilege pursuant to this specific subject matter. And because I successfully argued this, the court said to me through this mandate, hey, look, we know what you're doing now. We figured it out. Duh. And when you get your emolument privilege, we're mandating that you stand right here. This is a mandate in standing. Okay? So this is basically, I know the way it reads, but it's basically, look, we know what you want to do. We want to limit you right here to stand here in this particular cause. We'll deal with it later on. If it works out later, hey, we can always expand the mandate, right? And of course, because I'm willing to work with them, which I do frequently, this is kind of a neat project in that a couple of things also came out during this proceeding. Because this monopolized form of government is technically speaking not lawful, and it's based on this de facto corporation. That goes back to who manages corporations. It's not the bar. Pick up the phone and call any corporation, including a bank. You're either going to get sent to the fraud department, which is actually a sub-department of loss prevention. Okay? So what's the job of loss prevention? To defend the corporation. So when I showed them that, look, this has been my job throughout my entire career, now that I know what design I'm working with, which is this one, I have to show you that with this social control, remember the Pentagon, I did that, and how that is actually one of the reasons why people don't even comprehend what they're fighting is because they haven't even thought about the Pentagon. They think of the Pentagon as the excuse me, the military industrial complex. But it is a design. That building was designed that way for a reason. It is what it is. So kind of the long and the short of this is, if we're going to talk about law, the law of the land, okay, through the Republican form of government, when addressing this with Congress, I had to remind them that, look, I know about the Restructuring Act and the Social Security and blah, 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 blah. What you guys are missing with this unlawful enforcement, and again, I know where this came from, and it wasn't you guys, but you have to oversee this. They're trespassing this law to the point now that it is self-evident. And it was self-evident based on the actions of May 1st, and I won't go into that again. But this was the law of the late republic abolishing the acquisition of predial servitudes through prescription. Slavery, right? Making you work for money, or no money, as it turns out. And again, through this is a manipulation of these advantages, these profits, and these gains, okay, of these offices. So I'm going to go into right now, and I'm going to share and go into this a little more detail. This is important when we talk about what just happened with William Barr in his confirmation hearings, and why this is so significant in that, I forgot to share the audio there. Well, anyway, as you listen to it, you'll kind of get the idea.
So, in my opinion, if a president attempts to intervene in a matter that he has a stake in to protect himself, that should first be looked at as a breach of his constitutional duties. Whether it also violates a statute, depending on what statute comes into play and what all the facts are.
Including the Emoluments Clause of the Constitution.
Well, I think there's a dispute as to what the Emoluments Clause relates to. I have not personally researched the Emoluments Clause. I can't even tell you what it says at this point. Off the top of my head, I would have said, well, emoluments are essentially a stipend attached to some office, but I don't know if that's correct or not. But I'm sure, I think it's being litigated right now.
I don't know either, so I'm going to try and find out. We'll come back another day and maybe discuss it. Your memo.
Okay, so we're going to recap that. What you just listened to is, when I started this, I said at the beginning, remember the Ohio Democrats tried to take my initial work, okay, in the Emoluments Clause, that judicial report, and write a complaint against the president, which got laughed out of federal court, which still cracks me up, because they tried to weaponize emoluments once and it failed. These people are bound and determined they're going to weaponize the government. So when we go about where the Pentagon is, or the use of the Pentagon, the military-industrial complex, that's where those weapons are created. That makes sense now for you, I think? So anyway, doing this job, I see this exactly what it is. This is a corporate takeover of our de jure form and style of government. It's been in the works for years, and of course we can litigate Agenda 21 some other time. And yes, I know about all the videos of Nancy Pelosi and these various other senators or congressmen or whoever lobbying to pass Agenda 21. I know all about it. Point is look across the globe, and across the globe everybody said, look, we know what you're trying to do. You ain't going to get away with it. And, oh, by the way, we know who's doing it. We know who's at the center of it. So nice try. Too bad, so sad. We like our countries respectively. Pick one, right? And we're going to continue to do business the way we've always done it, because that's just who we as a culture are. Pick a culture. So again, this is the cause and the effect. The cause was when I started this, going after this cluster, right, in here, this segment from the dictionary. I saw this, what it is, okay? The original word dating back to the 15th century, okay? And then somebody coming in and trying to, in 1991, literally rewrite or recreate the law, the Constitution, overwrite it or weaken it, right? Under the premise of some obscure piece of history. Now, if you read through the history that they've cited here, some of it, this is what we go through in court. It's based in half-truths, right? It's not the whole truth and nothing but the truth. It's a half-truth and a lot of conjecture. And I do mean a lot of conjecture. So, though based in the, though written in 1991, and its basis is in constitutional law, okay, because it is Article 1, Section 9, Clause 8, and of course, let's see, they refer to it as Article 1, Section 6, Clause 2, okay? So, again, this is why I said we're starting to see the conflicts, because the word emoluments, when we talk about the intended purpose of what of naming our government after its advantages, profits, and gains of the offices, this is our de jure government. Our de jure government is the emoluments, the powers, the limitations that we gave it. Are you kidding me? Really? Hang on. never rains, but it pours in my office. Anyway, what time is it? 6 o'clock. It's still ringing. Anyway, so where was I here? Okay. So now that we've covered the actual basis of the word coming from the 15th century and exactly what design they're going to use to try to usurp and steal our government through a corporate entity, right? That was instituted for one reason and one reason only, to do foreign business. So they're literally trying to catch the president in a catch-22 situation in that part of his job is to deal with foreign dignitaries. So basically they're trying to prosecute him for doing his job. Let's just call that spade a spade. And if you go back again through history, every campaign or president or nominee or whatever, they at some point introduce themselves to foreign dignitaries or foreign leaders. It's just the way of things. It's the way it's always been. So when this actor, these political parties, specifically the liberal Democrats, they're again trying to go back to this design, right? They're trying to further wedge themselves into power. They're trying to change this design and bring this point down to like somewhere in here, right? And they're taking over more and more and more of the government, right? That's just the way this is working out, or that's what they're trying to do. So again, now let's go back to agency practice. Let's back up a little bit here. Now, in order for agency to exist, there must be a valid offer and acceptance clearly articulated in a contract, any contract. Without this step, agency representation cannot exist lawfully. This is the fundamental principle that goes into this legal maxim. What I cannot do in my person, I cannot do through the agency of another, right? So if the contract is not lawful, in other words, I can't contract with somebody to break the law, right? Pick a law. I mean, you know, yes, we joke about how, like in Nevada, prostitution is legal. That's thinking about is the only place it is. So, you know what I'm saying? I mean, that's just one example. Murder. I don't think anybody can contract lawfully to commit murder unless, of course, you're the CIA or NSA. But anyway, again, exceptions to every rule. Let's go into one of the reasons why the fruit of the poisonous tree doctrine plays such a key role in the agency practice. And this fruit of the poisonous tree doctrine is predicated on any evidence, either real or imagined, that is obtained or used either unlawfully or illegally, is excluded in any court or judicial proceeding under the exclusionary rule of evidence and specifically applied by this doctrine. This is the doctrine right here, the exclusive fruit of the poisonous tree. Okay? And this is the actual definition from the dictionary. One of the reasons why that this is applicable to pretty much every one of our cases, because there has been a seizure or arrest of some form that was not lawful. The reason it was not lawful is because that contract, okay, whether it was predicated on a false statement in an affidavit, somebody asserting some form of jurisdiction or power that they don't have, okay, whatever. Let's see, where did I find that? Yeah, so we were talking about agency, okay? In the if the contract was not created lawfully, and of course they're predicating their services under contract, so we can nail them to the wall with this, and that's exactly what I've done. is, especially in my case, and I'll get into that in just a minute, and you're going to laugh when you see this. So, yeah, in order for agency lawfully to exist, and again, how do I know that? How can I articulate that better than an attorney? Because a bar card is not a license. It's not attached to anything. It's just my library card. Your library card means more than that damn bar card does. And the fact that I know that and beat them to death with it, they hate me for it. I don't care. This is a license registered with a state agency to do specific agency do business under agency rules that Congress wrote. It's got nothing to do with court, got nothing to do with the bar, got nothing to do with anything but that. Okay? So because of that, this is the reason why you're going to hear a lot of, you can't do that, you can't do that. Yes, I can do that. You have to prove that I can, and good luck with that. Because the claim and exercise of a right cannot be converted into a crime. That's Miller versus U.S. So if I choose to lawfully use my credential, that screwdriver in my toolbox, to act in a lawful manner, lawful conduct, right, and provide for the common defense, I can assert a duty there. And that duty comes from the preamble of the Constitution. So I want to see somebody challenge me with that and win. I dare you. I double dare you. I triple dare you. Let's go to you want to come after me with that? Let's file your paperwork. Let's go to work. I will rip you to shreds. Trust and believe on that. So now that we've covered that, I just want to get that out of the way. Going back to the SCOTUS question again. Let's go back to this. My original intention was a parliamentary inquiry into Congress, right? That's this thing right here. But because the judge clearly saw and recognized what it was I was doing as lawful, meaning full of law, the documents notwithstanding, of course, they are prepared exactly the way you should prepare a document. At least when I do a document, this is how I do it. I put everything on the friggin' cover page. What you're about to read is confirmation of what you just read on the cover. So, again, this seems to be the general gist of the way. Not only was this accepted, it seems to be the more preferred method now. So, again, not an unintended side effect, but hey, it is what it is. So that said, when the judge issued the mandate and said, okay, you want me to stand here, I'm going to go and drop this in under a notice of process, which I did, and to the United States Supreme Court. You know, again, we're talking about unlawful emoluments, right? And because the judge issued a standing mandate. Well, guys, I know we had this discussion, and I wasn't going to bother you with this, but because apparently the court now decides they want to play loss prevention too. All right, well, here it is. Sorry to bust your stones, but we're back, and we're gonna talk about this parliamentary inquiry and what's this based on. Okay, so because I was able to, and we've been down through this, okay, 10 Commandments, which of course is our style and form of our judiciary, where that comes from, and I know I'm not going to argue with anybody on that. That's just the way it is. This was something that I wanted to introduce, not just into the inquiry process, to remind Congress, hey, if you're going to make a rule, if you're going to do anything, take any action, it's got to go through these 10 steps, right? And I even included the definition of a quorum for anybody who wasn't paying attention. And the reason that we know this, in order to be valid, any action or decision of a body must not violate any applicable law or constitutional provision. In my case, the constitutional provision was Article 1, Section 11. It's clearly articulated on the cover page. I mean, it's a no-brainer, man. And we know that because I went back up to here. There it is, Florida Constitutional, Article 1, and of course all of these sections by definition, but more specifically sections 9 and 11, because section 9 is due process, section 11 deals with debt. And now we're talking about the process and the subject matter in between sections 9 and 11. So the rest of this stuff is just, it is what it is. Like 13 is habeas corpus and, relative other stuff, but I won't bore you to tears on that. So this was how I literally kind of got sucked into going to the Supreme Court, which like I said, I didn't really want to do this. I wanted to be able to handle this through Congress and let Congress go in there and say, you know what, you're right. We need to figure out a better way to manage this practice. And your idea to use this tool in your toolbox, right? Let's take that educational mechanism and put it back where it belongs, put that power in the hands of the people. Because, how many of them a lot of them, they've come out and admitted already. I can't make those arguments. If I do, they'll take my bar card. That's a limitation. That is coercion, right? But you have to pay me anyway. Well, no, I'm not going to pay you if you're already under coercion to not do the job I'm paying you to do. That would be one of those insane things. That would be an act of insanity. And again, because I clearly am able to articulate every one of those circumstances, including the ideology that goes into them, okay, it is what it is. The judge is condemned when the guilty party is acquitted. And any judge who exceeds his office or jurisdiction is not to be obeyed. Let's see here, I believe it's an unjust law is not law. Or no. No, that's not that one. Anyway, one of these is also is precedent accomplishes nothing if it settles one dispute by creating another. I think that's actually this one. But anyway, could again, I could be wrong. But the whole premise behind all of this was to demonstrate to the court, look, I know what the ideology is. I know how the process works. I've just elected to stay the hell away from it because I have better things to do with my life than to play court with and argue with people all day long. If I wanted to have an argument, I'd go get married again. But that's a joke, by the way. So skipping ahead here, let's go down to the negative nexus. This is contained in the document. If you're going to make an argument, and in my particular case, I was trying to figure out a way to focus on just the negativity, the conduct, right? Again, that comes from these two legal maxims, okay? Negative destroys a negative and both make a positive, or just a negative destroys a negative, or two negatives make a positive. That's the second one. So, again, pursuant to Article 1, Section 9, Clause 8 of the U.S. Constitution, right, and under 28 U.S.C. subsection 1927, that's basically Congress's version of what they would like to see a litigator do. Okay, I just expanded it, said, hey, you're going to talk about contracts and you're going to provide these quote unquote services. Oh, well, yeah, I do services all day, every day. What do you want to know? And of course, the rest is history. But in order to construct this, I had to go through it slowly, and I do mean slowly. It only took 3 years to finally get to the point where I had to make them recognize, oh, third-party practices, guess what? We've been doing that for a long time. Even the court recognizes it pursuant to the rules, 14 and 37 specifically in federal court, right, in civil procedure. So, again, introducing just the negative context, okay, the report showing the negativity, and that's showing that -1 is not equal to 1. Those things are not equal. That was me showing Congress that though the court sees it as a +1, right, giving the court the benefit of the doubt. Why? For two reasons. Number one, because of the way things went here, okay, the relationship between me and the judge here was able to remain more de jure because of the fact this case crossed state lines. And he knew that I didn't want to go after Judge Rentala any more than, I didn't like it any more than he did. But under the circumstances, it is what it is, because up here, I had already shown the court that there was a negative. Okay? So when I do my reporting to Congress, okay, showing and literally proving this negative, this is how in calculus, these are how you prove negatives, right? You have to demonstrate them. So, and that's one of the reasons why it worked the way that it did. So now that I've shown you how Lady Justice is victimized, and Lady Justice is, when we're talking about maintaining the truth in the record, truth fears nothing but to be hidden. Okay? So the fact that they hide this stuff and they exclude exculpatory evidence, crap made up, as you'll hear me refer to frequently. This is why Lady Justice is the victim. And because I was able to clearly articulate that, and who is Lady Justice? Well, so as far as our ideology, truth is the mother of justice. So if you're going to victimize the truth by hiding the truth, you're victimizing Lady Justice. And it's not a stretch to point that out. Again, it's the reason that this mandate was issued. So just to cover this for you, and I know what the others are saying. I really don't care. I could care less. Point is, here it is, granted standing, which, like I said, I didn't want to do this. I would have preferred to leave her out of it, right? I don't want to fight with her. I've said it how many times? I do not want to fight with you. So this is between me and these guys, me versus them. This is what happens when you want to ride the train of loss prevention. And they're just going to figure out that they walked into this with a disadvantage in that, dude, you got in here subordinating perjury. I gave you the benefit of the doubt. Quit trying to subordinate perjury. They decided they were going to try to insist on it. Well, that's to his own detriment, and his being this jackwagon from the Department of Revenue, and I'm not even gonna mention his name. He's a dumbass. Just say that the way it is. Here's another thing that came out, right? Youngstown, Ohio, kind of 1,000 miles away from Ocala, Florida, from January 30th, 2018. What did they do? What did this agency, this Children's Services, they're like, oh, I know that guy. Yeah, if there's a 1,000-mile gap plus in there, chances are any allegations of whatever style or form, then not only can they not substantiate them, they literally kicked this. They kicked it out. Literally did. I mean, here's the language of how they got rid of it or tried to get rid of it. And somebody, don't know who, talk about gluttons for punishment. I just got this in the mail today. I should have gotten it a few days ago, but you'll see on the letter or on the right here, January 15, 2019 was when it was stamped for shipping. Somebody had a typo. Remember that address problem I've discussed? Here's a clear example of it. This one, I believe, was unintentional. They got it right on the first one, which was, which is here. They got it right here, but somebody typoed it here. So that's the reason this letter from December 28th of last year didn't get to me until today. So I wonder how long it went through the mail and various other places before it got back to them as undeliverable, because this address doesn't even exist here. Wonder how many. I'd love to know how many mailboxes or post offices that sucker hit before it got back to Ohio. The stories this document could tell. So anyway, in accordance with our state rules, this letter is to inform the status of the assessment conducted by our agency. Based upon our findings, the case is transferred regarding the children, right? Transferred to where? Well, I'll find that out, obviously, on Monday, because I just got the letter today. And so I said, as I went down through this, it was just like, you can't make this stuff up. If these guys wanted to pick if they wanted to pick a fight with me, now would have been the opportune time to do it, right? So if as recently as December 28th, right before New Year's, they decided they weren't gonna. They don't want to pick a fight with me because they know I didn't do anything wrong. They've been telling them that for how long now? Since long before January. Referral date was January 17th. So evidently since before January 17th of 2018, they've been telling everybody that, look, this guy didn't do anything wrong. Christ, he's 1,000 miles away. What the hell can you say that, what do you want us to do? Go grab him and, harpoon him out of the sky with his Iron Man suit? I mean, what do you want me to do? So they've kicked it out. So I'll find out where this is on Monday. I just thought this was hysterical. So anyway, this was one of the reasons why this was the primary reason I was granted standing in the court, which, again, I didn't want to do this. For the record, I don't want to play court. I want to go back to doing my job, one I had before I got sucked into this mess. So that said, I'm going to stop this recording. I'm going to go back to Facebook and I'm going to try to answer some of the comments before I shut down the Facebook live stream. So that said, let me stop sharing that. And